The European Union Data Act officially took effect on September 12, 2025, and it's one of the most transformative data sharing regulations we've seen since the GDPR. But unlike the GDPR, which focuses on protecting personal data, the Data Act is about unlocking access to data. For legal teams, this means a complete rethinking of contract terms, data governance, and third-party risk management. The Act's goal is simple: ensure that data generated by connected products and related services is accessible, usable, and shareable, not monopolized by manufacturers or service providers. It's part of the EU's broader digital strategy, building fairness and innovation into the data economy. Here are the 5 core obligations your legal team should focus on. 1. User access rights. Businesses and individuals must be able to access the usage data generated by the products or services they use. Contracts should clearly define how, when, and in what format that access is provided. 2. Third-party data sharing. Users can now instruct data holders to share their data with third parties, often competitors or analytics partners. Legal teams must ensure proper confidentiality, IP protection, and security clauses are in place before enabling such sharing. 3. Switching cloud and SaaS providers. The Act introduces a right to switch for data processing services. This means your vendor and SaaS contracts must allow data portability and migration without imposing technical or financial barriers. 4. Unfair contract terms. The Data Act limits the use of unfair data sharing clauses in B2B agreements. Legal teams will need to revisit template language around ownership, exclusivity, and license duration. 5. Public sector access. In specific cases, public authorities can request private sector data for the public good. Legal teams should prepare internal protocols for responding to these lawful access requests. For legal operations professionals, this is a call to action. Your contract lifecycle management, vendor onboarding, and data mapping tools must now track who holds what data and under what legal basis. This isn't just a compliance exercise, it's a risk management imperative. Failure to operationalize these obligations could lead to regulatory penalties, contract disputes, and even criminal liability for data misuse. Here's how to get ahead. Audit your current contracts for clauses restricting data sharing or access. Update vendor and cloud agreements to include migration and interoperability rights. Train business units on when third-party data sharing is permissible. Document lawful bases for data transfers, both personal and non-personal. And collaborate with privacy, IT, and compliance teams to build a unified governance framework. The EU Data Act is reshaping how data is controlled, shared, and commercialized. For legal teams, the challenge is clear, but so is the opportunity. By modernizing your contracts and compliance systems today, you position your organization to compete confidently in a data-driven economy. Want to stay updated on what's new in data protection and privacy compliance? Subscribe to this channel and visit our website at www.globalprivacynavigator.com to join our newsletter.